Welcome back. In this installment of video lectures for government, we're going to take a look today at the federal courts and the judicial branch more in general. This will be video lecture number 1, so we'll be beginning with some background and actually some information that you guys probably already know, at least in part, I hope. So in this lecture, here are some essential questions and goals that we will try to cover, and hopefully you will know by the end of the lecture. So what does the Constitution say about justice? What important precedent did Marbury versus Madison of 1803 establish? What was President Jefferson's response to Marbury versus Madison? And what do presidents today do when they disagree with the judicial branch? And what is a law anyway? Since we're getting into the idea of justice, it might be helpful to understand what a law is, so that when a law is broken, then we know that there is recourse to a judicial process in the United States. So I think those are the things we're going to cover. So get ready. Again, take some good notes. Any questions are always welcome in class. So the Constitution. What does the Constitution say? Well, we now need to move on to Article 3. And in Article 3, we see two sections, 1 and 2, that state, and I am paraphrasing here, but the essential ideas are these. Some of them you see there on your screen. And I quote, "The judicial branch of the United States shall be vested in one Supreme Court, and in such inferior, that is lower courts, as the Congress from time to time shall ordain and establish. The judicial power shall extend to all cases arising under this Constitution, the laws of the United States, and treaties made under their authority." End quote. So I kind of compacted that so that you got the essential idea about the Supreme Court being the top court. There are lower courts, and all cases arising in the United States will be heard through these federal court systems. Now remember that there are also 50 states, and states have their own court systems. You might remember this from the Articles of Confederation, and one of the problems in the Articles of Confederation was there was no Supreme Court, no national or federal system of courts. Each state had its own courts, its own procedures, its own interpretations of law, and that created quite a mess and a lot of chaos, in particular when we looked at commerce and property and those types of things. So the Constitution of the United States creates a national or federal court system that is comprised of different layers, and we'll get into those different layers a little bit later on. But we're going to look more today at the Supreme Court, which you see pictured here. So let's move on. And again, we're going to start with a little bit of background. Alexander Hamilton and Federalist number 78. But once again, we have wonderfully precise language that defines the powers of the court and the court's relationship to the other branches of the federal government, right? Hold on a minute. Again, what the heck? Yes, once again, we see that our vaunted founding fathers and framers created a framework, hence the name framers, for the judicial house, but they did not really build the walls, the rooms, lay out the rooms, add doors, windows, or any other amenities and features that you would expect to find in a house. That was going to play out over time, and specifically through a series of individual court cases that have occurred over the past 210, 212, 13 years. So what makes our study of the court system easier is that we've really already seen and studied some of the Supreme Court cases, believe it or not, and the important precedents that those cases have in fact established. So hopefully this is not all new, but let's take a look at a little bit of history and a little bit of context, history, or background. During Thomas Jefferson's presidency, 1801 to 1809, the federal government was still young, some 13 years old. Now, why bother? What does this mean? This really means that things were still being worked out, both within the single branches of the federal government and among the branches, that is, the relationships between the different branches. There were growing pains and experimentation because, again, the framers provided a framework or a structure, but didn't really fill in anything else. So I found this interesting piece, an idea from Alexander Hamilton, a co-author of the Federalist Papers and a secretary of the Treasury under George Washington, and he wrote in Federalist number 78 that the judiciary branch was the least dangerous branch of the federal government because, after all, the president was the commander-in-chief and controlled the military. Congress had the power of the purse and the power to declare war. And what power did the Supreme Court command? Well, when Alexander Hamilton wrote this in 1787, in 1788, the years those Federalist Papers were composed, the Supreme Court really didn't have a power, any power. It was ill-defined. And again, remember, the framers don't do a good job, or they do a really good job because they let things evolve over time. So it depends on how you look at it. Well, and again, you should know the answer by now, dear students, that the Supreme Court's and its powers would not be fully defined, if they're fully defined even today, but we can really pinpoint the moment in time when the Supreme Court's powers begin to take on greater definition and clarity, and that is, again, the 1803 case Marbury versus Madison. So we can flip to that slide there, and we can see Marbury versus Madison, and we see Chief Justice John Marshall. John Marshall's seated on the left there. Marbury and Madison are on the right, and there's I think, a funny kind of political cartoon by Riley, not Riley Baver, but by some guy named Riley, who does this for a living, who decided to take a look at the Judiciary Act of 1801. I won, you lost. It's a revolution, says Thomas Jefferson to the outgoing president, John Adams. And John Adams replies in a nice way, well, I have a surprise for you, John Marshall. And you see the iron anvil about to drop on Jefferson's head, who says, what's going on? Well, we can talk about that, and you guys know a little bit about this case, the partisan politics of the election of 1800. Remember that Chief Justice Marshall was a Federalist appointed by the outgoing President John Adams. Thomas Jefferson was the newly elected Democrat-Republican, and remember, he won the election by a hair. He was chosen by the House of Representatives because there was a tie in the Electoral College. So at this point, Jefferson comes into office, and he has a new Secretary of State, Madison, who was supposed to have delivered a commission to a man named Stephen Marbury, who was going to become a judge in the Circuit of Washington, D.C., and Madison declined to deliver that commission, which was, in Marbury's case, at least according to him, a problem. Marbury wanted the job. Remember, government jobs were lifetime secure income. So Marbury went to the Supreme Court. Now, Marshall could have simply issued an order to Jefferson and his Secretary of State to deliver the commission. Case over, case closed. That would have been in keeping with the 1789 Judiciary Act that created the inferior courts and tried to spell out in part some of the powers of those courts. Marshall, however, decided that that would not be a good idea, that would not be a wise path to go down. So Marshall sidestepped the direct confrontation with Jefferson and his administration by declaring that the 1789 law passed by Congress, the Judiciary Act, and remember it was signed by George Washington, was that it was unconstitutional because the Constitution said nothing about judges being able to issue orders. Remember, they were called writs of mandamus, if you recall that term. And that essentially the writ of mandamus is the power or the authority a judge has to issue an order. Do this, do that. Well, Marshall said, wait a minute, the Constitution doesn't give that power to judges, therefore that law is unconstitutional. So Marshall could have issued an order to Madison, deliver the commission. He doesn't. He avoids that direct confrontation because he understands that he then might be impeached. It might not be politically wise. So what does Marshall do? Well, Marshall, in avoiding direct confrontation with the Jefferson administration and the risk of impeachment, Marshall established two important and defining points that still apply today. First, laws that contravene, a fancy word for going against, the Constitution are void. Second, it is the Supreme Court's duty to say what the law is. That is, it is the Supreme Court's duty to say what laws contravene the Constitution. So what Marshall is essentially saying is it is the job of the Supreme Court, and in particular, it is my job as Chief Justice of the Supreme Court to say what the Constitution means and therefore what laws mean. So John Marshall was really grabbing the ball and running with it. So he limits the power of the court by saying the judges have no authority to issue orders, but they can say what the Constitution means, and if laws go against the Constitution, then those laws are null and void. So Marshall then, with this ruling that he hands down in 1803, really defines the powers of the Supreme Court and its role. He begins the process of defining the relationship between the Supreme Court and the President and the Congress. That had not happened before. Now, one of the other things I asked, or one of the stated at the beginning of the lectures, well, what was Jefferson's response to all this? He's about to get hit by the iron anvil after all, right? Well, we know something about this because Jefferson was an avid letter writer and a prolific letter writer, and he wrote a letter to his friend Abigail Adams, ironically, the wife of the outgoing president. Kind of an interesting twist in history. But in this letter to Abigail Adams, Jefferson articulated his view that each department or branch of the federal government has its own powers and responsibilities to interpret the Constitution. Now, we've talked about this, I've mentioned this in class, but I wonder whether this is really sunk in. This is what Jefferson calls departmentalism, and Jefferson rejects John Marshall's taking the ball and running with it. He rejects Marshall saying it is the Supreme Court's sole duty to interpret the Constitution and what laws mean. Jefferson says no, each department, that is, branch of the federal government, has its own powers and responsibilities to interpret the Constitution. And in particular, Jefferson was referring to a president's power to pardon people who he felt were unfairly convicted by the court system itself, which led Jefferson, again, to state the presidents can interpret the Constitution themselves. And I also, in that essential question at the beginning, said, well, what do presidents do today when they disagree with the Supreme Court? Well, this battle goes on. This relationship between the branches and the struggle to define that relationship goes on. In 2010, President Obama, in his State of the Union address, called out the Supreme Court members who were seated there in the hall, and this was bold, and he called them out in that speech because President Obama was steaming mad that Congress, or that the Supreme Court rather, in its Citizens versus the United States decision, overturned campaign contribution limits in federal elections. This was something that incensed Obama, incensed many Democrats, and made many feel that the court was really siding with wealthy conservative elites who funnel money into elections through political action committees and different outside sources, if you will. So the president in this case was calling the court to task directly and in person. So that is really kind of an interesting thing, and this is going to be an ongoing debate. The same Supreme Court, however, also upheld President Obama's Affordable Care Act, which Obama supported, obviously. So it's really interesting in an ongoing case-by-case basis how we can see this relationship playing out. So at that point, we can get into the idea of law, and that will end our lecture. So what is a law? Well, the scholar Cal Jillison, and I've been reading his work and using it from time to time, says that law and law courts play a larger and more powerful role in the United States than in any other country in the world. In most countries, the courts simply apply current law. In the United States, however, courts judge current law and policy in the light of the more fundamental law of the U.S. Constitution. End quote. So the Supreme Court in our country, in our political and judicial system, does much more than just looking at current laws on the books. You see the law books there that contain those laws. The Supreme Court really looks at current law and policy in the light of the Constitution. And remember, you should remember by now, is the Constitution very, very precisely worded? I'll pause. You should answer in your notes. Okay, I think you got the idea. So that if the Constitution is not precisely worded, then who's going to define what the Constitution means? And this has been an evolution, and it will continue to evolve. So some give great credit to the founders for not having written a really, really precise, detailed Constitution, rather allowing there to be endless room for debate and interpretation over just what the Constitution says and means, as society changes, as we as human beings change, as we discover more information, as we do different things, the Constitution then can change because our interpretations change. And it's the Supreme Court that is involved in the United States, which is rather unique in the world. So we're going to end there. Sorry, we will get to the idea of law in the next lecture. Thank you very much.